Is this you with our son?
Yes,
So you did raise him since he was
yes,
a baby, correct?
correct. But he's not my biological son, and you know
And
this.
do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, Your Honor.
Okay, thank you. You can both lower your hands. And counsel for the Attorney General's office.
Julie Damani for the Attorney General.
And I guess, Ms. Lewis, I'll let you proceed since it's your pleading. I've read it and I understand there's no agreement on it.
That's
So
correct, Your Honor.
you can
And Your
proceed.
Honor, before we begin, I did have exhibits 1 and 2, which was just the same thing as attached to the motion. I didn't know if it would be okay to publish it through share screen, or I believe Ms. Damani told me that you have another way that you like for them to be published or
Yeah,
shared.
and Mr. Monty, just so you know, usually if an attorney has exhibits, the way my other offices handle it is they just ask for the link to be sent before the hearing begins, and then they just put it in for them. Because as you well know, it was very hard to set up. Like a lot of AGs are struggling with it. So I don't expect someone who's not familiar with Case Center to necessarily use it in a timely manner. I find it usually takes a long time during the hearings. So
Oh,
I don't know
okay.
if you have access, Mr. Monty. I guess we can pause the hearing and create one of those now, if that's how y'all want to do it.
Your Honor,
Mhm.
if I may, they're attached to the motion. I don't know if that makes any difference. It looks to me like they're the same as what's already attached.
And that's correct, Your Honor. So, I mean, if the court would, I mean, I could ask the court to take judicial notice of it.
I can do that. I take
Okay.
judicial notice of the affidavit and his exhibit 2. Does anyone, I take judicial notice of the affidavit and the time card details that are attached to the pleading.
Okay. Thank you. May I proceed, Your Honor?
You may proceed.
Okay. Mr. Correa, can you please state your full name for the court?
Francisco Correa Barriga,
And where do you currently reside?
1507 Stone Mesa Drive, Houston, Texas, 77073.
How long have you lived there?
For like a year and 6 months.
Okay. And were you living at 1507 Stone Mesa Drive on March 26, 2025?
Yes, I was.
Okay. And where do you work?
I work for Admiral Glass Company.
What are your normal work hours?
My normal work hours are from 5 in the morning to about 5 in the afternoon.
Okay. And on March 26, 2025, what time did you report to work?
I was already on the clock and at work at 5 a.m.
Okay. And you have provided documentation via your time card for that week. Is that correct?
Yes, ma'am.
And does that time card reflect you clocking in for work at 5 a.m. on
Yes.
March 26, 2025?
Yes, ma'am. And being out at 5 p.m.
Okay. And have you seen the documentation? Well, let me ask you this. Were you at your home? Was it possible for you to be at your home at 7:02 a.m. on March 26, 2025?
No, ma'am. I was already at work since 5 a.m.
Okay. So if a return of service states that you were served on March 26, 2025 at 7:02 a.m. At your residence, would that be accurate?
No, ma'am. I was already at work.
Okay. Have you ever personally been served with any court documents in this case?
No, ma'am. I have not.
Were you served with any documents on March 26, 2025?
No, ma'am.
Have you ever seen a citation or petition for this lawsuit prior to June 16, 2025?
No, ma'am. That is the
Okay.
day that I saw it on my emails.
Okay. And how many people live at your residence at 1507 Stone Mesa?
There's various family members, male and female, living there.
Okay. And are you aware of anyone at that residence may have mistakenly been
Intro
served
one.
in?
All right, guys. This courtroom hearing opened with a moment that immediately captured everyone's attention. A father acknowledged raising a young boy since infancy, yet firmly declared he was not the child's biological parent. That powerful admission instantly shifted the tone of the entire case. Moments later, both parties were sworn under oath, signaling that every statement would carry legal weight. As attorneys prepared to present evidence, it became clear this wasn't just another child support dispute. It was a complicated battle involving service of process, family relationships, and the truth behind a judgment that one side claimed should never have existed. With the hearing officially underway, the discussion quickly turned toward procedural issues before any testimony could move forward. Attorneys addressed exhibits, affidavits, and supporting documents already attached to the motion, while the judge carefully explained how evidence should be presented during virtual proceedings. Rather than allowing unnecessary delays, the court chose to take judicial notice of the submitted records, allowing the hearing to proceed efficiently. But everyone understood the real fight had not yet begun. The courtroom was now preparing to examine whether the defendant had ever been properly notified before a default judgment dramatically changed his legal situation. Here's where everything started taking a dramatic turn. The father identified himself, confirmed his Houston residence, and explained that he worked long shifts beginning at 5 o'clock every morning. His testimony centered on one crucial fact. According to his employment records, he was already working hours before legal documents were allegedly delivered to his home. If those records proved accurate, the official return of service could be seriously questioned. That single issue carried enormous legal consequences because improper service can completely undermine a default judgment and force the entire case back into active litigation. The testimony became even more significant as the questioning continued. The father repeatedly insisted he had never personally received court papers related to the lawsuit and only discovered the case months later after noticing an unexpected email from the court system. He explained that the moment he learned a default judgment existed, he immediately searched for legal representation instead of ignoring the matter. That response supported his argument that he had never attempted to avoid court. At this stage, the courtroom's focus remained crystal clear, determining whether the judgment had been entered without proper legal notice in the first place.
Mistakenly been served and presented any documents to you of this lawsuit?
Not that I am aware of. No, ma'am.
Okay, how did you first learn that a default judgment had been entered against you in this case?
I was going through my emails and I just happened to see that I had an email from the courts, and that's when I clicked on it and saw the information that was sent to me.
Okay, and when you received that order via email, what did you do thereafter?
I immediately started looking for a lawyer to represent and see what action I needed to take to get this resolved.
Okay, did you ever ignore any legal documents or intentionally fail to respond to this lawsuit?
No, ma'am.
And is it your position, had you have been properly served with citation in this petition, what would you have done?
The same thing that I did whenever I found out was immediately seek legal advice and get this resolved accordingly.
Okay, were you trying to avoid participating in this case?
No, not at all.
Okay, now let me ask you, you've seen the default order that was signed in this case, correct?
Yes, ma'am.
And of the children named in the default order, are you the biological father of all of those children?
No, ma'am. There's one of the children that I am not the biological father to.
And which child is that?
Aiden Jeremiah Korea.
Now, at the time that this child was born, you and the mother were married, correct?
Yes, we were married.
And you're still married, is that right?
Yes, ma'am.
Okay, and so though you are the presumed father of this child, is it your testimony that you are not the biological father of this child?
Yes, and both me and Miss Norma are aware of
I'm
it.
sorry, I don't mean to interrupt you, but Ms.
Okay.
Perea is making noises. Also, even though you are at home or you're outside, you are in court. So please treat it like court. Please try to get to a stationary location where you can focus on court and not be moving around and not having side conversations during court.
Yes, I am.
You all didn't reach an agreement, so it's real important that everyone hear what's being said. Obviously, you all care enough that you wanted a hearing, so you have to participate in the hearing fully. I require that. And then also, we generally take testimony in court. So if you are not the person being asked questions, please don't interrupt or answer or roll your eyes. Wait till it's your turn to be asked questions. If you don't have counsel, you will be given a chance to speak as well. And then, isn't that relevant for this? But I'm not with the Attorney General's office, so anything you've discussed with them or given to them beyond what's been done in court, I have no knowledge of, and I'm not supposed to have knowledge of. So just be aware of that as well. And you may continue, Ms. Lewis. And Ms. Freer, you're in a stationary spot now. You are focused and not having a
Yes.
side conversation? Okay, perfect. Let's proceed, Ms. Lewis.
Thank you, Your Honor. Do you believe that it's appropriate for you to be ordered to pay child support for this child?
No, I'm not the
And
biological father. No.
okay, and what would you request the court to do regarding this child if this judgment is set aside?
I just get removed from the child support. That that what's fair.
Okay, and if the court does set aside this default judgment, what do you plan to do as it relates to the marriage?
Um, we would want to file for divorce and do everything the correct way and get what's needed for the children done and do whatever we need to do to make everything right and get the proper documentation and everything done.
Okay, and would you have claims or requests that you would like to make regarding your property and children and marriage if you had the opportunity to present it?
Yes.
Okay, and no further questions for this witness, Your Honor.
Ms. Damani, do you have any questions for Mr. Correa?
Just one question.
Okay.
Mr. Correa, looking at the time card details
But the
attached
courtroom
to
wasn't finished uncovering critical details. The father testified that he never ignored any legal paperwork because, according to him, none had ever reached his hands. He explained that if he had been properly served from the beginning, he would have immediately hired an attorney and defended himself through the proper legal process. He strongly denied making any attempt to avoid participating in the case, emphasizing that his actions after discovering the judgment proved exactly the opposite. His testimony aimed to convince the court that this situation resulted from procedural failure, not intentional. Then came the revelation that changed the direction of the hearing. When questioned about the children listed in the default order, the father acknowledged that one child was not biologically his, despite being legally presumed to be the father because he was married to the child's mother when the child was born. He openly stated that both he and the mother had always known this fact. That testimony immediately raised complicated legal and emotional questions, transforming what began as a procedural dispute into a deeply personal family conflict with potentially life-changing consequences. At that point, the judge stepped in to restore order inside the virtual courtroom. Noticing interruptions, background distractions, and side conversations, the judge reminded everyone that this was an official legal proceeding requiring complete focus and respectful conduct. Every participant was instructed to remain stationary, avoid speaking out of turn, and wait until called upon before responding. The judge also clarified that the hearing was limited to deciding whether a new trial should be granted, not resolving every issue involving child support or paternity. That reminder narrowed the courtroom's attention back to the legal question before it. With order restored, the testimony returned to the father's requests if the judgment were overturned. He argued that continuing to pay child support for a child he insisted was not biologically his would be fundamentally unfair. Looking ahead, he explained that he intended to file for divorce and resolve every issue involving the children, property, and marriage through the proper legal channels. Rather than avoiding responsibility, he told the court he wanted every matter addressed transparently with accurate documentation. His testimony presented a picture of someone seeking a fresh legal beginning instead of escaping accountability.
details attached to the motion to set aside default judgment, it does not have your name on it.
Okay.
Where did you obtain a copy of that time card detail?
We have an app on the phone where we clock in and out, and you have to click by name to show you the correct details.
And so how can the court be sure that that was your time card?
I'm not sure if I can log into it and you see me click my name and it shows the time card. I'm gonna see if I can pull it up right now if there's a different way of showing the name or anything. Give me 1 second. Yes, there my name should be at the very top of the time card.
So are you doing this on your computer or on the device, the same device that you're using Zoom on?
No, I'm using another device.
Okay.
So I don't know if I can't screen share it, but I can send it to my attorney and then she can send it to you guys. But it does have my name at the very top. It says Korea Francisco Barriga.
If the court would allow it.
I will allow that.
I just have to click back to the date. Give me 1 second.
If you're able to do it on this device, you could screen share what you're doing.
No, I have it on my work phone. Is the one that has the
Got it.
phone application. Okay. Oh, I don't know. I could if y'all can see it on the screen here. It's Francisco Korea, and then you go to details, and then it shows all the dates and times.
Are you able to go a little closer to the camera? I'm not able to see it.
I'm gonna go back to the page where it shows my name, which will be here at the very top.
Oh.
Sorry.
Ms. Damani, were you able to see that?
I'm still not able to see it. I don't know if Judge is able to see it.
Yeah, you're probably looking at the earnings summary. If you look at the blue section on top, it says his name.
Yes, and then I just go to the details
Is that you, Ms. Damani?
for the week, and then it shows everything.
Yes, thank you. I have no further questions, Judge.
Ms. Correa, do you have any questions you would want Mr. Correa to answer?
Yes. So I thought this was court was about him not getting served, right? But they're bringing up about my son, and I just wanted
Hey, man,
to
your
show.
questions aren't for me. Your questions are to Mr. Correa. Is this a question for Mr. Correa to answer?
So yes. So
Okay.
my question is this him in the photo with me in the hospital?
That is me, but that doesn't mean he's my biological son.
Okay, hold on. One more question. Is this you with our son?
Yes, I'm not gonna neglect a kid, a good father, just because his father wouldn't step up to the plate. Correct?
So you did raise him since he was
Yes,
a baby, correct?
correct. But he's not my biological son, and you know this.
And did you or did you not tell me that it was going to be your way, that he had no dad, you were the dad, we were married, and this was your
Objection, Your
son?
Honor,
Objection as to
relevance.
relevant. Oh, sorry, relevance.
I'm going to sustain the objection. All I'm addressing today is whether or not I'm going to grant the new trial. So those issues will definitely be at some point addressed, assuming they pursue their claim. But I'm not ruling on that issue today.
Then the spotlight shifted to one piece of evidence that could determine the outcome of the motion. The Attorney General's office questioned the father's work time records, pointing out that the document presented to the court did not visibly display his name. That challenge immediately placed the credibility of the evidence under intense scrutiny. Remaining composed, the father explained that the records came directly from his employer's mobile timekeeping application and offered to demonstrate exactly how the system worked. Suddenly, the hearing evolved into a battle over whether the employment records could be trusted. All right, guys, this became one of the hearing's most important moments. Using a second device connected to his workplace application, the father carefully navigated through the employee portal while everyone watched. He attempted to display his profile information and the detailed work history, showing he had clocked in long before the alleged service of legal documents. Although the camera angle initially made the screen difficult to read, he patiently adjusted the display and offered to provide additional verification through his attorney. The courtroom was now examining real-time evidence instead of relying solely on paperwork. After several attempts, the court and attorneys were finally able to identify the father's name displayed within the application. The questioning attorney acknowledged seeing the identifying information, bringing that line of cross-examination to an end without further challenges. While the evidence would still be evaluated alongside everything else in the case, the demonstration strengthened the father's argument that the submitted time records genuinely belonged to him. With no additional questions from opposing counsel, the hearing prepared to shift toward testimony from the child's mother, introducing an entirely different perspective into the courtroom. What happened next completely changed the emotional atmosphere inside the courtroom. The mother presented photographs showing the father with the child shortly after birth and asked whether he had raised the boy throughout his life. Without hesitation, he admitted that he had proudly cared for the child since infancy. However, he immediately repeated his central claim that despite acting as a father, he was never the child's biological parent. As emotions escalated, the mother attempted to explore conversations from their marriage, but the judge sustained an objection, ruling those issues were outside the limited purpose of the current hearing.
Do you have any questions regarding the new trial?
Nope, that's it.
Okay. Ms. Lewis, do you have any other witnesses you'd like to call?
No other witnesses, Your Honor.
Okay. Ms. Damani, do you have any witnesses you'd like to call?
No witnesses, Your Honor.
Ms. Correa, you do not have an attorney representing you. So if there's anything you'd like to say regarding the new trial, now is your chance to let me know any concerns you might have about it.
Only for the case that he says he did not get served, correct?
Yes.
Okay. I mean, no, I have no other questions. He makes up his own time card, so that's the only thing I have to say.
Well,
It's an app that you have to clock in on site.
Sir, right now, no one has asked you any questions.
Apologize.
Does everybody rest? Does anybody anything further they wish to present?
I rest, Your Honor.
Ms. Damani?
Nothing further, Your Honor.
Okay. Ms. Correa?
Nothing further.
I'm going to grant the new trial. And I'm going to reset the case to be heard. For anyone to file, consult lawyer. You may want to consult a lawyer, Ms. Correa, to file any necessary pleadings. If they do file a divorce, there's a good chance this will get consolidated with it and not be before me, but who knows? We'll reset it just in case, and then we'll see what's happening by the time that setting comes. July. What date would you like to use, Ms. Damani?
Judge, either September 30th or October 17th.
Will September 30th be enough time for everyone to prepare?
Yes, Judge.
No, not for me.
How much time do you need, ma'am?
I would like until October.
Judge, I would just like to let the court know that I am prep set in Harris County for a 3-day trial on the 16th, 17th, and 18th, I believe, of October.
The 18th is a Saturday. Do you want to?
Okay, so then maybe it's Wednesday, Thursday, and Friday. Let me
so
see.
It's the 15th, 16th, and 17th. Okay.
Okay.
If we don't do that, we would be moved out to October 28th.
Okay.
That would work, Judge.
So the AG's well. Ms. Damani, are you going to prepare the order?
Ms. Lewis, did you have an order?
I believe so. If I didn't file it, I can get it filed this morning. I apologize about that.
If you can send it to me, and then I can get it to Judge for signature.
Sure, will do.
Thank you.
Okay. Okay. Then everyone is free to go, and we'll see what's happening on October 28th.
Thank you, Judge.
Thank you.
With testimony complete, the judge gave each side one final opportunity to present additional witnesses or arguments regarding the request for a new trial. No further witnesses were called, and the child's mother expressed her primary concern, questioning the reliability of the father's electronic time records. The father briefly attempted to respond, but the judge immediately reminded him to wait until he was officially recognized before speaking. Maintaining strict courtroom procedure, the judge ensured both parties had been fully heard before announcing that the court was ready to deliver its ruling on the motion. Then came the moment everyone had been waiting for. After considering the testimony and evidence, the judge announced that the request for a new trial would be granted. That single ruling erased the effect of the earlier default judgment and reopened the legal battle for a full hearing. The judge explained that the case would be reset, giving both sides an opportunity to properly present their claims and evidence. She also advised the mother to consider obtaining legal representation, noting that future divorce proceedings could eventually become connected with this family law dispute. Attention quickly shifted from the ruling to scheduling the next phase of the case. The attorneys discussed available court dates, balancing preparation time with existing trial commitments already scheduled in other courts. After reviewing several possible dates and resolving scheduling conflicts, the judge approved a later hearing date that would provide both sides with adequate time to prepare. The discussion reflected the practical reality of family court, where procedural planning is just as important as testimony. Every upcoming filing and legal strategy would now shape the outcome of the reopened case. As the hearing came to a close, the judge instructed counsel to prepare and submit the necessary written order reflecting the court's decision. Once the paperwork was finalized, both parties were officially excused and reminded to return for the next scheduled hearing. Although no final determination had been made regarding paternity, child support, or divorce, the legal landscape had changed completely. The default judgment was no longer controlling, and both sides would now have the opportunity to fully argue their positions before the court. The real legal battle, it seemed, was only just beginning.